This is Barry Zalma on Insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the trigger of coverage with regard to property damage. The term trigger of coverage means what event must occur for potential coverage to commence under the terms of an insurance policy, and what must take place within the policy's effective dates for the potential of coverage to be triggered, brought into effect, required to respond to a claim. This was in Re Feature Realty Litigation, a 2006 decision of the United States District Court for the Eastern District of Washington. After the California Supreme Court adopted what it called a continuous trigger in Montrose Chemical Corporation versus Admiral Insurance, a 1995 decision, Montrose, in the case of successive policies, concluded that property damage that is continuous or progressively deteriorating throughout several policy periods is potentially covered by all policies in effect during those periods, so that the insurer's duty to defend arose under those policies. Insurers trying to limit their coverage revised the policy wording because they did not believe that they really intended to do what Montrose Chemical's decision said they did. Therefore, the precise question to an insurance claims person is what result follows under the language of the policies of insurance to which the parties have agreed. The continuous injury trigger has been applied mostly in cases involving gradual release of pollutants and other environmental harms. After Montrose, the insurer revised its policies to use the language for the very purpose of obviating the application of the progressive damage continuous trigger articulated in the Montrose decision. As a result, the defendant's policies state that property damage which commenced prior to the effective date of this insurance will be deemed to have happened in its entirety prior to and not during the term of this insurance. This was stated in Insurance Company of Pennsylvania versus American Safety Indemnity Company, a 2019 decision of the California Court of Appeal. The Louisiana Court of Appeal ruled in a different case that allegations by a property owner that an environmental consultant failed to detect the presence of pollutants on its property did not trigger coverage under the consultant's liability policies. The court found that the occurrence giving rise to the claims against the insured took place years before or prior to the issuance of the policies in question. Reaching a decision that comported with that of a majority of the states, the Louisiana court said, quote, "In order for there to be coverage under these policies, the property damage must have occurred during the policy period. The property damage was the contamination of physical injury to the property, which was caused by previous owners and users of the site. GTL's liability is hinged upon its failure to detect the contamination. Even if the property is not considered physically injured property damage as defined by the policy, it includes, quote, or subquote, loss of use of tangible property that is not physically injured, close subquote. However, that loss of use is deemed to occur at the time of the occurrence that caused it. That occurrence predated the policy by almost 7 years. Accordingly, the property damage did not occur during the policy period, and coverage was unambiguously excluded. This was Herzog Contracting versus Oliver, a 2005 decision of the Louisiana Appellate Court. Whenever a claim is made for damage to property, it is essential that both the insurer and the party making the claim determine the date and time when the property was actually physically damaged. This is simple in an auto versus building case because you know when the auto hit the building. It is more difficult to determine in cases such as pollution cases and asbestos cases, where the exact timing is difficult to pin down, and sometimes it goes over several policy periods. Claims should then be made only to the insurer on the risk, the one whose policy was in force at the time the physical damage occurred, not the policy that was in force at the time a suit is filed. Now, while the term trigger of coverage is not a term used in an insurance policy, it is, as the California Supreme Court said, a convenience used to describe that which, under the specific terms of an insurance policy, must happen in the policy period in order for the potential of coverage to arise. The issue is largely one of timing. What must take place within the policy's effective dates for the potential of coverage to be triggered? Because the occurrence policy, as distinguished from claims made or claims made in reported policies, cover occurrences that result in injury during the policy period, the courts in California and elsewhere have concluded that the policies are invoked or triggered when the injury takes place. Consider State versus Continental, a 2012 decision of the California Supreme Court, Armstrong World Industries versus Aetna, a 1996 decision of the California Court of Appeal, Pennsylvania General versus American Safety, a 2010 decision of the California Court of Appeal, and others. The word trigger, as a term of art, means the event that activates coverage under one or more insurance policies. The trigger of coverage problem arises in determining exactly what must take place within the policy's effective dates to trigger or bring into a requirement to respond insurance coverage. Different states apply different triggers of coverage, including 1. The manifestation trigger, shown in Rando versus Top Notch Properties, a 2003 decision of the Louisiana Courts of Appeal. 2. The exposure trigger, consider Insurance Company of North America versus 48 Insulations, a 1980 decision of the Sixth Circuit. 3, the continuous trigger, consider King County versus Travelers, a 2019 decision of the U.S. District Court for the Western District of Washington in 2019. And 4, the injury in fact trigger, recognizing the existence of various triggers of coverage in National Insurance versus ASRock, a 2000 decision of the Fifth Circuit. To date, no Texas state appellate court has discussed which trigger of coverage theory should apply to a first-party claim under a standard homeowner's policy based on continuing or progressively deteriorating damage to the insured's dwelling. When the Travelers issued a policy that provided coverage for injury or damage that happens while this agreement is in effect, it limited its coverage to that temporal requirement that applies only to the injury that occurs while the policy is in effect. Travelers bargained for an injury-based trigger of coverage, not an act-based trigger. Under the policy's plain terms, Travelers must defend any claim in which covered injuries occurred between 2005 and 2011, the policy periods, regardless of when the wrongful causal act occurred. This was Travelers versus Mitchell, a 2019 decision of the Fifth Circuit. Simply applying the manifestation trigger to a homeowner's claim for progressively deteriorating property damage to the insured's dwelling without discussion of other trigger of coverage theories is simply improper, according to State Farm versus Rodriguez, a 2002 decision of the Texas Courts of Appeal. This video was adapted from my book, Zelma on Insurance Claims, Part 102, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com as part of the 10-volume set, Zelma on Insurance Claims. If you found this video to be useful or of interest to your colleagues, please pass it on. It's free. And please subscribe or follow me on my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.